Please unmute those speakers. This is important. I know people actually watch videos these days on social media and on the internet without turning the volume on. And I do it. I don't know why humans do it, but just please, if you're watching this, unmute those volume speakers. That way you can hear my voice. Google does their best. Facebook does their best, I should say, also to transcribe and to do closed captioning. But they pick up all the ums. I'm a big ummer. I don't know if you guys are ummers as well. But please, yeah, check that out. I want to get this out to as many people as possible. And so the best way to do that is make sure you're hearing me loud and clear on this morning broadcast of the Bold Today Show. Hello out there. We got 2 live viewers out there already. This is great. Thank you for joining. I want to hear from you guys. I want to hear live questions. This is the fun stuff. When I used to go out and present, pre-COVID to groups of inventors, entrepreneurs, that was the best, right? When I could get real live, even sometimes angry questions coming from the audience. That's what, sparked my energy. That would keep me on my toes. And I love, there's an again. I would love to respond to that because those are people on the streets, bootstrapping, making it happen, the inventors that I love to serve. All right, so I'm going to post what I do every week here is a disclaimer. Please, if you're listening to this live, and even if it's after the fact and you're looking to make a comment or a post, please do not share your confidential information. This is not the forum to do so. So check out that paragraph I just put in there. This is a live Q&A session where I hope to provide legal guidance, but not legal advice, right? Not specific to your confidential invention. I want to give you the law as it is and how it relates to technology and inventions. So if you have a question, please do try to phrase it in a hypothesis or in a anonymous way so I can get to your question on the show. If I can't, if it seems too particular, I will have to have you send me an email, and I'll put that email address in here for you right now. That is my email address for you to send confidential information to follow up for perhaps a free consultation. All right. So without further ado, I want to let you know that I was hoping to have one of our favorite clients on. He wasn't able to make it today, so I'm hoping that we can bring him on next week, Wednesday. We're going to talk about patents and trademarks and how they work together very well as you're developing a new product line. This particular inventor has gotten, I think, 4 trademarks to cover their products as they hit the market. And they're in the very popular, still popular space of e-cigarettes, vaping technology. So for those that are into that field, interested in hearing more about that, make sure you're tuning in next Wednesday, 9 a.m. Pacific, noon on the East Coast. I will be there, and hopefully our client will be as well. So just me today. You're stuck with old JD. But again, if you're watching this live, I will take your questions as priority. And without further ado, I'm going to jump to the avlo.com questions. I do want to invite you to please grab a copy of my book. I put that link up there. I'll do one more time here in case you missed it. I hadn't been posting this link. This is kind of a sneaky link directly to a free download of the whole book. So you're lucky if you're looking at this post. It's a digital download of this book, Bold Ideas, The Inventor's Guide to Patents. This is your, pocketbook of what is a patent? How do I get started? What's the difference between trademarks and copyrights and patents and trade secrets? It's on the book. I did also write this book. You might see behind my big head is You're Not Alone. Okay, this is sort of a personal, anecdote. I go on for quite a while, but it's really passionate. This is from my heart about what it means to start a company. And believe it or not, a law firm is a company, and I'm in it with you. And if you're starting this journey of an entrepreneur, it is a lonely process. All right, you've got to do a lot of, forging, right, hacking through, carving your own trail, and blazing it on your own. This is sort of a book to remind you that no, you're really not alone. You've got a lot of mentors, advisors, people around you that care and love about you. And I want to be there to help encourage you to move forward down that journey, because that's how we're all going to become better. All right, let's go to these avlo.com questions. For those that are new, don't know about Avlo, that is where I volunteer as an attorney and answer questions from around the country that are coming in regarding patents and trademarks. And so I feel it's my duty to respond. Those anonymous questions come in from all over the country, lots of different states. And so instead of just typing an answer, I want to give a live answer here on my show today. I don't see any questions live, so I'll jump to those 2 questions we had that came in last week. This first one is a little off topic, but I thought I would bring it in, okay? Coming out of Mojave, California. I'm trading a product that promises hair growth in case the product doesn't work. Will I get in trouble? Uh-oh. I'm buying products to sell them internationally. They're hoping to sell them in the Middle East, but I'm not sure about the efficacy of the product. Will I get in trouble if people don't see the result after using the product? Okay, interesting. So hopefully, you know, your product does what you say it's going to do. I think in many ways, you know, the legal answer is it's going to depend on the consumer protection rules and laws in the jurisdiction that you're selling. I have no clue what those laws look like in the Middle East and, you know, specific countries within the Middle East, but you're going to take a look. I think if you want to be ahead of the game and be wise as to potential lawsuits and, you know, mitigating any type of risk there, I would hire an attorney based in the Middle East, those countries you're hoping to sell into, and make sure that the labeling, make sure that the advertising and the marketing and potentially even the customer service follow-up that surrounds that product will protect you. And I think a simple disclaimer, hey, no guarantees as to actual outcome. Outcomes are based on blah, 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 right? Trials or hypothetical, you know, theoretical solutions or outcomes, right? With respect to a hair product. Again, I don't believe that's squarely at all within patent law. That's really more about consumer protection law and more about the, you know, advertising, proper labeling. And so I would advise you, if you're going to be selling in the U.S., to also engage an attorney, not a patent attorney, but a business and more general practice attorney that can help advise as to products and product labeling. All right, I hope that answers your question there. Let's jump to the second question, which is, again, from Avo. Trademark application serial number 900-33430, response to an office action draft. Okay, so this person has filed a trademark application and is given that serial number, and they're asking, what's the likelihood of having the mark granted? I think they mean registered for the trademark side, by asserting over 10 years of use under 2F. Okay, interesting. Well, this is a very direct legal question. I don't think I'm going to provide a full answer right here on the air. What I will do is provide for our audience and for the question asker's benefit, my approach and how I would set up and investigate to answer this question. Quite frankly, I would want to charge money to answer this question and to give a legal opinion on what to do. I wouldn't want to give that away for free, mainly because obviously I'm going to be out of business if I do that. But really, the big reason is I need to spend time researching the office action, meaning what the trademark examiner said, this isn't going to work, and making sure that if I give an opinion that it's founded in that research. So I'm going to post a question on our Facebook channel so those that are watching can look and follow along. There's that question that came across on trademark, okay? So let's see here. This is serial number. So what I want to do is show you a couple things. I'm going to share my screen and show you where I would go to begin that research. All right, so this is TESS, the Trademark Electronic Search System. And you can go to tmsearch.uspto.gov. That is the place to begin your search. I'll put that in the comments here for you to look at, where you can begin to search trademarks. Okay. So let's go to a basic word mark search. Okay. And we're going to put in that serial number. And I would go back here and grab that number. And you just put it down below. And now down here, you don't want to do a combined word mark. You want to go to the drop-down menu and make sure it's serial or registration number. You're searching both plural and singular versions. and the live and dead marks. There it is. Okay, so this question is coming out of this company, at least the brand, etax.com. And it looks like from this, here's the serial number, so that's a match. They filed it over the summer, July 2nd, 2020. They filed it under 1A. That's the basis, meaning it's an intent to use. So they wanted to kind of reserve the name, etax.com. And they have to, what you can do is file that way with the intent to use the mark in service. You don't actually have to be selling or using that mark in commerce when you file, but you've got to provide a specimen. And I believe that's what this is coming to a head. The person's wondering, hey, what do I provide? How do I provide evidence that I've been using the mark in commerce? And it looks like they have made a claim that they've been providing a website with software that users can file tax forms. They've been doing it since 2009. Okay, first use in commerce, April 15th, tax day, 2009. So if that's true, all they've got to do is provide evidence that they have done that. And so that could be through webarchive.org or through other affidavits, receipts, or sales showing they were using etax.com in 2009. So that would definitely be something you could use if you've got that evidence going back. I do question as to why they would have filed under 1A in July. If they had clear evidence, they've been using it for 10 plus years, why wouldn't they have included that in the initial filing? So again, if you have detailed questions about this, you want to follow up more, I've given my email address out. We can help you answer more specific questions. The place to go find where their current status is, right? This is not a registered mark. You can go look at the TSDR, tsdr.uspto.gov will provide you status on a pending trademark application. Okay, and I just gave that link out to everybody. All right, so what you're going to do is come here, and again, with that serial number, let me just go grab that. And click on status right here. Okay, so you can see this is a, application date July 2nd. And a non-final office action has been sent. This letter is from the examining attorney requiring additional information or making an initial refusal. So if we go down and see what the prosecution history is, you can click this and see what was the examiner saying. So just 2 days ago, that office action was sent over, and you can look at the documents to see just what that office action says. It's all public record, something you should know when you are making an application is there's no way to keep this private. You can even see the email address for the individual. So they've said the reference application has been reviewed by the trademark examining attorney. The issues, the mark is merely descriptive, and the improper use of federal trademark registration symbol. So maybe they got caught using the R with a circle on their website. I'm pretty curious. I want to kind of go to etax.com and just kind of see what they've been up to. So, yes, you can see right up top, if you can see my monitor, etax.com, they're using the R with a circle, which means it's a registered trademark. And indeed, it's not, because they're still dealing with the trademark office. They have not got it registered. Okay, so that's a whoopsie. Got to make sure you don't violate that rule. What they should have done is use a simple TM, letting people know that they're hoping to use that to represent their brand, and they're on their way to getting registration. So being merely descriptive is probably a hurdle they can clear. The problem with that is that you may not get a registration for federally a trademark that just merely describes what you're doing. And so this may be something that could be overcome, but the trademark examining attorney says, look, you're just electronically helping people file taxes. Therefore, e-tax really isn't distinguished from the actual service you're providing, right? If you're If you're just selling water bottles and you're trying to protect waterbottle.com or water bottle as your trademark, that's going to be just merely descriptive, and you'll likely have to go on to what's called the supplemental register. Anyway, I digress. This kind of got a little bit away from me, but I wanted to show you some of the ways that you begin to research and to see what it would take to help get a trademark application registered. All right, let's stop sharing and come back to our screen. Do we have any questions at all from today? Flavio, hey, good to see you again. All right, yeah, you're welcome. So you'll be given a notice of allowance for your design patent moving forward to a priority filing for the utility. So I guess the USPTO gives you time to file for both since no one has claims on it before sending out the issuance. Absolutely right. So before your parent application gets issued, you want to make sure that you get everything else that could be related, in terms of utility, other designs, child patents, related continuations, all filed before that first parent patent issues. After it issues, you're in trouble because that patent will now act as prior art against yourself and will prevent you from being able to file future patents on that same subject matter. So good for you. You've got 2 patents. You're building a patent portfolio. You're well on your way to really making a big dent in the market and carving a nice sized niche. So thanks for that, Flavio. That's a great point. All right, guys. I know day after election day, everybody's probably watching the election results. No live questions right now, so I will let you guys get back to your day. Again, if you got questions, if you want to forward this on, give us a like, share this on your social, get this out to the inventors that you may know, right? Uncles, friends, nephews, nieces, moms. I mean, anybody out there really can be an inventor. This is my passion. I want to make sure I educate, inform, be here every week with you live to help kind of nudge you along. I feel like everyone's got solutions to problems out there, and patent law is there for you to help protect you and get you into the market in a very simplified way that is part of the foundation, right? That's part of the Constitution. All right, everybody. Well, thank you for tuning in. I hope you're here next week. I'm JD Houvener with BOTH Patents Law Firm. Go big, go bold.